I'm not going to be tolerant of that at all. It doesn't sound like that was what it was about. And I'm talking, these can't be mixed messages. If he's talking specifically about bills, he's talking specifically about bills. And that one can look at. But if he's talking about other things, particularly things that may relate to the case or try to play on the emotions of the victim or anything along those lines,
It's nothing like that.
So certainly I will hear it when you listen to them all, and you can give me a fuller explanation as to the entire contents of that. But at this time, I am going to order that the defendant's phone and texting privileges are revoked. Is Mquest.
Good morning, Alexander. Good morning, Your Honor. My name is Mary Carthew. This is Matthew here appearing on behalf of our client, Ms. Mquest, as student attorneys under MCR 8.120, under the supervision of attorney Sarah Salen.
And you're requesting permission to practice, I presume. I missed that part of it. Okay. Permission to practice is granted. All right. What are we doing? I have a plea sheet. Is that what?
I believe so, Your Honor.
Is that correct?
Yes, Your Honor.
All right. The plea agreement indicates that the defendant will be pleading no contest to the charge of domestic violence first offense. The 93-day misdemeanor. Upon her successful plea to that charge, count one would be dismissed. Further indicates that there is a sentence agreement of no upfront jail. That's the court's entire understanding of the agreement.
That's correct, Your Honor. Yes, Your Honor.
All right, very good. May I have the defendant sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth?
I do.
What's your name?
Mackenzie Mquest.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes. Yes.
Well, do you understand that those are the maximum penalties?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
Two things about it I have to make sure that you understand. First, it first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Sir.
All right. Basis for the no contest plea, counsel?
Your Honor, Ms. Mquest has accepted.
Oh, no. Somebody's going to come up and whisper.
Oh.
Yeah.
This is civil
Civil liability. Your Honor.
liability.
We just came back from break, Judge.
Pardon?
They just had a week off of school.
So.
Monday morning, a week off of school.
So that doesn't. Why are you doing excuses? It's okay. She didn't need an excuse, but when it was going to turn into a full sentence, I'm like, anyway. All right. So, ma'am, to the charge of domestic violence first offense, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
Or you signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will.
Yes, sir.
And because, well, I won't ask that question. Court has been provided Pittsfield Township Department of Public Safety report for their case number 2519132. Any objection to the court reviewing that report?
No, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be.
Wait. It's the same day and time as the other hearing.
Or April's.
Huh? What's the problem?
April 6th work? Yeah, that's
Okay.
fine.
Yes, Your Honor. April 6th, please.
What's wrong with the 30th?
Yes, sorry. County on that date.
Oh,
I do.
more trouble? Never mind.
Can I plead the fifth?
Probably best you do. Sentencing in this matter will be April 6th, 2026. 1 p.m., correct? All right. Will you guys still be here? Or you guys would be on another break or something?
We'll be here, Your Honor.
Sure.
Yes.
To work around this school schedule. All right. Okay. Bond will continue. All right, thank you. On your way out, stop down on the left-hand side, my probation department is down there. Stop in and check with them so we can start the sentencing process.
Okay.
And Your Honor, I just wanted to add, I believe on the docket today, there was that bond violation.
Yes.
We aren't intending to proceed on that today. I would just ask the court to reiterate the no contact in the meantime until sentencing.
All right. Continue the no contact. You understand that?
Yes, sir.
All right. I don't expect to see any more even indications that there's any. Understood?
Yes, sir.
All right. Thank you.
Thank you, Your Honor. Thank you. Thanks, guys.
Court stands in recess. Oh, Ron? No, I'm good.
Contacted the victim's listed number from his pin in the jail about 10 times with
13th, 2026 at 8. Both of those proceedings are in person.
Your Honor, if I could address bond.
Ma'am.
It's come to my attention that Mr. Evans has contacted the victim's listed number from his pin in the jail about 10 times with 48 attempts. The most recent completed call was on March 2nd. So at this point, I'm going to ask for phone privileges and texting privileges to be revoked.
Your Honor, it's our information that he was making these calls in relation to DTE, his daughter, his stepdaughter, Cormora Evans, informed him that the family's DTE energy had been shut off, and he was making arrangements to have family member, his sister, Kathy Ann Evans, go over, pay the bill so that the services could be restored.
And it got cut back on.
And it was turned back on.
And Your Honor, I did want to note, in the one call I listened to, I did not hear mention of VC. I also have concerns given that he had the bond violation when he was out of custody, said he was going there to help pay bills. Is now in custody for this violation of the no contact order, was told not to contact her, and then was contacting her. At this point, it
Well,
first time.
But my information,
I'm unclear. Why would the
stepdaughter call him.
need to be contacted?
He was calling his stepdaughter. 313-756-0770
But the
for Mara Evans.
stepdaughter, are you saying it's a landline
It's
or is it a cell phone?
cell phone. It's her cell phone.
Whose cell phone?
It's her cell phone.
Her being whom?
The daughter.
But that's not the number that was called.
That is the number that is called, Your Honor, and that was the number that's listed for the victim in the police report, and from the conversation, I'm not sure.
Yeah, ain't no shit.
But Your Honor, the stepdaughter informed him that they had $196 bill that was passed due services, electric services. I'm sorry, DTE was shut off and the stepdaughter needed to
How
actually.
many calls were there?
10 completed calls, 48 attempts that were not completed.
I hear what you're saying, but I don't know that it would take 2 calls to do that.
Well, they had to go back and forth because
Oh, what?
the stepdaughter had to contact his sister Kathy Ann Evans, who lives in Toledo, to come up and make arrangements for the payment. Kathy Ann Evans is his sister, 440-619-9656. She's helping the family out while he's incarcerated so that they can eat.
I
Keep the-
hear all of that, but I'm just trying to, why is there gonna need to be 40 attempts and 10 completed calls to get this accomplished?
I can't speak to that. All I can speak to is the urgency in his mind to keep the family, the utilities on. It's cold outside, Your Honor. They need gas for the stove.
It did get cut back on too, Your Honor. I was just trying to do the right thing, make sure everything was right. Even being in here.
He's trying to save his job at across the street. He's told he could still work at KFC. He saved money.
I get all of that and I can appreciate it. And maybe if there had been 2 or 3 calls trying to get that arranged, one could do that. But was DTE mentioned in any of the calls?
I didn't get a chance to listen to all the calls. The most recent call I listened to was the one that occurred on 32, and that was mention of you hurt me, I love you, things like that.
Well, today is the 9th. The DTE situation occurred around last Monday, the 2nd, Your Honor.
Yeah, but that's not what he's talking about when he's on the phone in that call.
And there were calls.
That was a different thing.
And Your Honor, we've had situations where people have been charged and they don't pay the bills. They don't pay the phone bill. They don't pay the rent, and the complaining witness gets evicted. So we have the reverse here where he's trying to do the right thing. He has $500.
That were the entirety of the subject matter of the calls. Okay, but that doesn't sound like that's the entirety of the subject matter of the calls. Also, the number of the calls doesn't make any sense. And I think Ms. Zenda was saying that there are calls before that shutoff day.
Your Honor, I have calls on January 3rd. I have calls on January 6th, January 30th, February 1st, February 5th, February 16th, February 22nd, February 23rd, March 2nd.
And all payments.
Those can't all be about the DTE bill.
Not just DT, rents, everything. I'm sorry.
His rent is $1,586 a month, Your Honor. And he's depleted his savings down to $500
Yes.
to try to keep the family afloat.
That's what I'm gonna do. If you want to bring it back by motion after you listen to all of the calls and are able to tell me that all of these calls, the subject matter of all of these calls involve bills or like, I will be more than happy to listen to that. But just from the brief statement by the prosecutor in terms of what was said, it doesn't sound like that was what it was about. And I'm talking, these can't be mixed messages. If he's talking specifically about bills, he's talking specifically about bills. And that one can look at. But if he's talking about other things, particularly things that may relate to the case or try to play on the emotions of the victim or anything along those lines,
Nothing like that.
Let him talk.
Okay.
We have
Sorry.
our chance.
I'm not going to be tolerant of that at all. So certainly I will hear it when you listen to them all. And you can give me a fuller explanation as to the entire contents of that. But at this time, I am going to order that the defendant's phone and texting privileges are revoked. Thank you. Court calls the case Driscoll versus Jeremiah Driscoll.
Haley said on behalf. Your Honor.
Ron Brown appearing on behalf of Mr. Driscoll.
Just keep your hands out your pocket.
Your Honor, thank you for the opportunity. He was on the 1 o'clock docket, but I notified the court that he wanted to be heard in person. This is his chance to tell the court why he believes he's a good candidate for early discharge from probation.
Go ahead.
Is that correct?
Go ahead.
Yes. Mr. Driscoll, state your name for the record, Judge.
I am Jeremiah Driscoll.
Thank you.
Here's a Blair on behalf of probation. Your Honor, Mr. Driscoll is before the court for a review hearing. He did submit a request for an early discharge from probation. Mr. Driscoll has completed 12 months of a 24-month term. He has completed the domestic violence program, paid all of his fees, and is reporting as directed. I did reach out and speak with the victim in this case. She is supportive of the early release request. Probation would defer to the court as to the defendant's request. Defendant has a statement for you. Here.
Go ahead.
Good afternoon, Your Honor. I just want to say that I learned a lot over this year. I have no control over no situation that don't, that's not me. Only thing I have control over is myself and no one else. And, taking the time out, sometimes you gotta just separate yourself, just like even on social media, you gotta separate yourself. You can't just be on there all the time. So like I learned a lot this past year, and I feel like, that I just want to move forward, and keep making the best decisions.
So I'm not going to see you again.
No. Only time I might see you is on the internet. That's it.
That was fair. I wasn't asking for that, but I got it. All right. Again, as I look through and I'm looking through the file, it is clear to me that, as you go through this, there was not one. And actually had gotten yourself to the point where each of the proceedings after the first one or the second one, we were able to waive your appearance because you were doing so well.
Yeah, thank you, Your Honor.
And through that. So, since the victim is also supportive of this call, I'm going to grant your request. I'm going to discharge you from probation with it to close this case out.
I thank you, Your Honor.
Your Honor, Matt
Yeah.
he wants TV stars, saying,
Yeah.
autograph. What's your autograph?
My autograph. I can't.
You are famous,
Oh, I'm not
Garner.
here doing my job. I just meant, okay.
What's your autograph? Told you I'd get it.
Absolutely.
I appreciate it.
Personal.
Thank you.
All right.
Thank you.
Take care.
Thank you. You too.
Okay.
Right. Court calls the case People versus Cat Robinson.
At least that's on behalf of you, Your Honor.
Ron Brown appearing on behalf of Mr. Robinson. Mr. Robinson, please state your name.
And Robinson.
Okay, this is that form I told you got to sign. Would you sign it for me? He's pleading as charged, DV.
Plea form indicates that he's pleading to domestic violence and 93 damages.
Yes, Your Honor.
All right. May I have him sworn?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
State your name, please.
Ken Robinson.
Sir, it is this court's understanding you're going to plead guilty to the charge of domestic violence. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes,
In understanding that, do you still wish to plead guilty to that charge? How do you plead?
guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes,
Signed an advice of rights form, correct? Any question about those rights? Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
Probation.
Okay, we were on probation at the time of this offense?
Yes,
Yes?
yes,
You understand that if your entrance of a plea of guilty in this case could be a violation of that probation. You understand that? You understand that that court then could sentence you to the maximum allowable under those other charges. You understand that?
yes,
And understanding that, you still wish to plead guilty to this charge.
yes.
Has anybody promised you anything other than what's been stated here today on the record to get, which is really nothing, to get you to plead?
No,
Anybody threaten you or coerce you?
no,
Doing this voluntarily
yes,
and of your own free will?
yes,
And also because you believe that you are indeed guilty of this offense? On the date of January 14, 2026, location of 3000 Carpenter Road in Pittsfield Township, Washington County, State of Michigan. What'd you do on that date involving a Sharonda Stewart boss that makes you think that you're guilty?
I hit her.
Pardon?
I hit her.
You hit her? Pardon?
Yes,
All right. Who is she to you?
my girlfriend.
Girlfriend? And when you hit her, you did that intentionally? Pardon?
Yeah,
Well, you're shaking your head. I don't know. Did you hit her intentionally or was it an accident?
it was an accident, but
Well,
I hit her.
take it.
Okay. Can we set it for final settlement?
Absolutely. March 9. Jury final settlement conference in this matter will be set for April 10th, 2026.
Not my decision, not my choice, I get it. He's doing that, he wants his job. I get it. It is what it is. It's old. Thank God. It's a shit case. It's better. What the hell is it? I have to worry with that. I said, because he might say, oh yeah, get to know it. Doesn't. So. God. You're fine. I was speaking about we have 6 people here. Exercise. For the scene. No. See, yeah. I was that's exactly right. You're not. No, that's not it. Get it. No.
When you get done talking, so lipstick, that's insurance.
Who is this?
Darren Lipstick, 2610048.
I guess great. I will dismiss them.
Oh, awesome, thank you.
All of the pieces. I don't know. Okay. Okay. Big accident. Oh, okay. Okay. Helsinki. I appreciate you. Appreciate you. Now, here's the thing. No airline. Wasn't like I was no bones get scratched, like just her scared for a second. Yeah. But
All rise. 14th District Court in the County of Washington, State of Michigan. Says all those before the court draw near. The Honorable Judge J. Simpson presiding.
You may be seated. Mr. Cook.
Morning, Your Honor. Bringing Cook to the people, Your Honor, the people waive any potential conflict between this honorable court and the office of the public defender. While people do not believe that any such conflict exists, make this waiver in the avoidance of all doubt.
Thank you, sir.
Morning, Judge Torshio Feast, the first assistant public defender. We likewise do not believe that a conflict exists.
But should a conflict arise, we will waive that conflict and ask this honorable court to please hear all matters before today.
Thank you. The court, for its part, also does not believe there's a conflict either under Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Angelo Andrews.
Morning, Your Honor. Raymond Cook for the people.
And good morning, Your Honor. Attorney Eric Chappell on behalf of Mr. Andrews.
Mr. Andrews, can you state your name, please?
Angelo Antonio Andrews.
Thank you.
Thank
All
you.
right. What's wrong? Their arraignments. And counsel, are you appearing on both cases?
Yes, Your Honor.
All right. So as to the arraignment, you're waived formal reading and your client stands mute.
We do, Your Honor.
And having waived formal reading standing mute, the court will enter a not guilty plea on his behalf. Today's the 4th.
Okay.
And where do we want to go from here?
Your Honor, we have submitted a offer to the prosecutor's office, hoping to potentially resolve the matter. Mr. Andrews drives for a basement waterproofing company. This is not like an over-the-road carrier or anything such as that. You know, we're hoping that we might be able to resolve it through the payment of some overweight fines and some civil infractions rather than misdemeanors. These are light duty dump trucks. On the day in question, just so the court has the context, there was heavy clay.
I don't know that I need the context.
Okay. Yep. Gotcha.
Do you want me to adjourn this so you guys can talk?
That'd be fine,
Yes,
Your
please,
Honor.
Your Honor.
Thank you. Yes.
Mr. Chappell, if you could just confirm what email you sent that to. I don't see anything in my inbox, but I can give you my email so we can talk directly.
Yep. Go ahead and give it to me. I know it was like I know it was an SA email as I was looking through the file earlier.
Yeah. So my email is cookr@washtenaw.org.
Will the 18th give you enough time or you guys need more time?
Your Honor, I think that would give us enough time.
During this matter to March 18th, 2026, 9 a.m. as your invite indicates. I'll set the defendant's bond at $5,000 personal recognizance bond, standard conditions, including no assaultive behavior or use of any weapons. All right, thank you.
Thank you, Your Honor.
Calls the case of the People versus Aaron Williams.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Williams, who is approaching.
It's an
Mr. Williams,
arraignment.
could you state your name for the record, please.
Aaron Williams.
All right.
Thank you, Your Honor. At this point, as it regards arraignment, we would waive formal reading, stand mute.
Been in every way, formal reading, standing mute, court will enter a not guilty plea. All right, what are we doing?
Your Honor, regarding bond, Mr. Williams is the father of 4 children. He works 2 jobs. He understands testing is going to be part of moving forward. The sober link and random testing do not work with the schedule of that is imposed because of the children and the jobs. So he's requesting a tether to test moving forward. We have a very low BAC in this case, but there is a prior from 2019. And Mr. Williams is
What is the alleged BAC?
0.083, Your Honor.
Thank you.
Bond in this case will be set in the amount of a $10,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possession of any weapons or ammunition. There's to be no use of alcohol, illegal drugs, or any recreational marijuana. I will order that the defendant is to report to community corrections for placement on a scram testing unit. And then I will adjourn this. How much time did you need?
Your Honor, if we could get 3 to 4 weeks, we do have several videos I've been told by my staff. We have not seen those. I've not had a chance to review the video evidence.
During this matter to, Joe Hall showing up on this date, that'd be about right. April 1st.
Funny enough, Judge.
26.
Well, Judge, the issue there is I am
What is
to
a
be
national holiday for you? right?
Orlando.
No.
Yeah, exactly, right?
Exactly. Yeah.
Your Honor, I think the world is fooling
Don't
me
take
that
your
day.
bad, it's a holiday. Go
Your Honor, I think the world's fooling me that day because I've been lured into going to Disney, and I will be,
Oh, Joe.
suffering in my own way, but I'll be out of state, Judge.
Oh. Well, when you go, say hi to the mouse.
I sure will, Judge.
Really, not for me, for Ann. I don't understand the mouse.
You know what? I'd rather.
But if you see Donald, him and I are more, we have much more in common.
And Your Honor, on the 8th, I'm in actually Charlotte, Michigan, in
I
person in
think
the
it's
morning.
Charlotte, but that's okay.
They tell me Charlotte. I don't know.
No,
to be honest.
right.
I wish
I think the way you said it is correct.
I wish I never had to learn, Judge. I already regret some things about that one.
April 15th.
That works for my calendar, Judge.
April 15th, 2026, 9 a.m. Bond will continue as said.
Thank you, Your Honor.
Thank you.
Good to see you, Judge.
Good to see you. I really do like the mouse. I do. We have issues at times. Court does call the cases of the people versus Byron Blair.
Morning, Your Honor. Raymond Cook, the people.
Good morning, Mayor, Police Court, Your Honor, Attorney Damian Cass, P number 85852 on behalf of Mr. Brian Blair.
Blair, can you state your name, please? Do you hear?
Yes, Byron Blair.
Byron Blair, thank you.
Ron Brown appearing on behalf of Mr.
All right, what are we doing?
Your Honor, on my matter, I am asking just for a brief adjournment to potentially the 18th or the 25th. I am seeking some information from a treatment facility that I have yet to receive so I can submit a deviation letter. And also asking is if the current potential offer for the 1-for-1 is still open.
The offer that was previously extended for 1-for-1 will remain open as long as the defendant remains compliant on bond.
I would join in the motion to adjourn.
Turn these matters to April 18th.
April 18th.
2026, 9 a.m. Thank you.
Thank you, Your Honor.
March 18th, I'm sorry, March 18th.
March 18th, okay. All right. Thank you.
All Joe Hall's fault. Court calls case, People versus Paula Johnson.
Raymond Cook, the people.
Oh, no, hold on. It's my worst nightmare.
Good to see you too, Judge.
Absolute worst nightmare. It's just,
Always a pleasure.
No, well, it's kind of a nightmare.
Okay.
It's like a very, I won't call it a nightmare. I'll call it like a really scary dream.
Understandable.
Okay. And that's.
I get it.
Go ahead, you guys state your name. The two of you together is just.
Dynamic duo, right?
Okay. That's you
I don't know, is that bad or good?
Of all the
Paula
attorneys,
Johnson.
thank you, of all
Yes,
the
sir.
attorneys you could get.
It is her lucky day. So, Attorney Hugo J. Mack, Your Honor, appearing with Ms. Johnson, dynamic duo.
This is now going to take a turn.
A good turn.
Well, I don't know. I'm just saying.
We don't know.
We don't know.
You know, Mr. Cook has come up with a brilliant idea, and my client is fully willing to comply if the court will allow it. So there's a possibility here, if Mr. Cook agrees to enter a deferred sentence on this matter, Judge.
All right, is she going to plea? Is that?
Yes.
Do I have forms?
No, Your Honor, I'm filling it out right now.
Okay. So everything's not done. You didn't let Mr. Cook know that's what you were doing.
Well, he knew, but he was so busy. They're so
Okay.
They're so overworked in that.
All right, so what I'm gonna have to ask you to do, has she signed an advice of rights form? She's
No.
not done anything.
No.
Yeah, dynamic, just dynamic. Listen, I'm gonna pass it, let you get all the forms filled out, then I'll call you back up.
Appreciate it.
Okay,
Thank you so much.
thank you.
No, that's not my fault, right?
What?
I said, that's not my fault. They didn't give it to me.
No, I know nothing is ever your fault. We've been through this before. Court calls the case, people versus, is it Zeke Church?
Morning, Your Honor. Raymond Cook with People.
And Judge, good morning to you and the staff. Vincent Haysha with and on behalf of Zeke Church, who's present through Zoom without objection.
Church, can you state your name, please?
Zeke Church.
Okay. And what are we doing? Are we entering a plea today?
We are.
Let's get my forms here. Forms I have before me indicate that the defendant will be pleading guilty to the charge of disturbing the peace, a 90-day offense. Upon a successful plea to that charge, count one would be dismissed. There is also a sentence agreement of prosecutors deferred. That's a court's full understanding of the agreement.
That's correct, Your Honor.
Ours as well, Judge.
All right, very good. Church, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record, please, sir.
Zeke Church.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
I'm trying to get to the court. It won't let me get to. Well,
Can Motorola, can you? Thank you. So, sir, just because we had an interruption there, you understand the maximum penalties, is that correct?
Correct. Yes.
And understanding those penalties, do you still wish to plead guilty?
Yes.
Don,
And to that charge?
It's a Don.
Okay. Whoever, one more time for the person marked Motorola, and then I'm just removing you from the courtroom. Sorry about that, Mr. Church. So, Mr. Church, to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct, sir?
No, I don't think so.
Zeke, this is the form that we went through that you gave me permission to sign.
Yes. Okay.
So you caused it to be signed on your behalf, is that correct,
Yes.
sir?
Correct. Yes.
Do you have any questions regarding any of those rights?
No.
All right. Looking at paragraph 5, those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights that are on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor.
On the date of March 29, 2025, at the location of 4095 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, what did you do that makes you think that you're guilty?
May I voir dire, Your Honor?
Yes, you may.
Mr. Church, that location that the judge just mentioned, was that better known as Besting Games in Pittsfield Township? At least to you? Mr. Church, can you hear me?
Yes. Sorry. Yes. Besting Games.
okay.
Yes.
Okay. On that date, were you present at Besting Games?
Yes.
Did you engage with two individuals that you did not know?
Yes, I did.
And while you were engaging, that involved some pushing and shoving?
Yes, it did.
And that happened, you'd agree, in front of other people in the general public?
Yes, correct.
And who of course observed this. Is that fair to say?
Yeah.
I'm
Public
satisfied,
did.
Your Honor.
All right. Would you agree, sir, that disturbed the peace and repose of the immediate area surrounding where you were?
Yes.
All right. Sir, I do have to advise you that if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Understood.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
None, Your Honor.
And have I complied with the courtroom?
Yes, Your Honor.
You have.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Well, yes. Defendant is referred to probation for pre-sentence recommendation and consideration of prosecutor's deferred sentencing in this matter will be
April 8th at 9 a.m.
April 8th, 2026, 9 a.m.
That's great, Judge.
Bond with its conditions will continue. Do I have probation? I do. Mr. Church, I'm going to ask you to remain online. We're going to put you into a breakout room with my probation department so we can begin the sentencing process. Okay, sir?
Okay, thank you.
Thank you.
Thanks, Judge.
Thank you. Court calls the case of the People versus Taylor Chapman.
Arraignment Cook for the people?
Ron Brown appearing on behalf of Taylor Chapman, Your Honor.
She here. Oh, there. Ma'am, could you state your name, please?
Taylor Chapman.
Thank you.
Your Honor, I'm requesting a brief adjournment in the matter. I wasn't able to talk to her.
Okay. Ma'am, I'll adjourn.
The judge's tone turns serious as concerns are raised about messages sent by the defendant. He makes it clear he will not tolerate mixed signals, especially if the communication goes beyond simple matters like paying bills. If the messages attempt to influence, pressure, or emotionally affect the victim that crosses a line the court will not allow. While the defense insists the messages were only about financial issues, the judge decides the safest step for now is immediate action. Until the full contents can be reviewed, the court orders that the defendant's phone and texting privileges be revoked. It's a sharp reminder that once a case is active, even a message can become a major problem. Question: should courts restrict communication when there's any risk of influencing a victim? Like and share if court orders should be taken seriously.